This is Law Bites, a podcast with Michael Geist.
A recent report from the Privacy Commissioner finds Mounties were using Clearview AI, an American facial recognition software. The software pulls your photos from Facebook and Instagram, then puts them into a database that Clearview customers can search. In addition to privacy concerns, independent studies of facial recognition find it can return false matches. The RCMP first denied using the technology, but admitted to it after Clearview's client list was hacked last year. The RCMP accepted the Privacy Commissioner's recommendations, but disagreed with the finding that Mounties broke Canadian privacy laws by using technology built with stolen data.
Earlier this month, the Privacy Commissioner of Canada released a scathing report on the RCMP's use of facial recognition technology, particularly its work with Clearview AI. The report was particularly damaging, as the Commissioner found that the RCMP wasn't truthful when it said it didn't work with Clearview AI, and then gave inaccurate information on the number of uses when it was revealed that it did. In fact, even after these findings, the RCMP still rejected the Privacy Commissioner's findings that it violated the Privacy Act. Lex Gill is a Montreal-based lawyer with Trudel Johnston and Lespérance, where she focuses on appellate litigation and public interest advocacy and teaches at McGill University's Faculty of Law. She's worked at the Canadian Civil Liberties Association, the Citizen Lab, and the Canadian Internet Policy and Public Interest Clinic, CIPIC. She joins the podcast to discuss the Commissioner's findings and to explain why this is best viewed as part of a long cycle of surveillance that has often targeted social movements or those facing socioeconomic barriers. Lex, thanks so much for joining me on the podcast.
Thank you so much for having me.
Yeah, no, I'm really glad you found the time to come on. You know, I think for many, the first inclination when they read or heard about the Privacy Commissioner's report involving the RCMP's use of facial recognition technologies and Clearview AI was one of shock. As you know, the RCMP initially denied using the technology, including to the Commissioner, which proved to be, or working with Clearview AI, which proved to be untrue, and then disputed the Privacy Commissioner's finding that they'd violated the law. Yet your response suggested that you weren't really surprised at all. You noted that the story is all the same: use it, hide it, deny it, get caught, retroactively justify. I thought that's a really powerful statement that I hope that we can unpack on this podcast. But why don't we start with the most recent finding? I know it's a bit of a big ask, but can you bring us up to speed on what happened and what the Privacy Commissioner found?
Yeah, no problem. I think it's really helpful to have this factual background. So let's do a little one-on-one. The report is about the RCMP's use of Clearview AI, which is a technology company that's offered services, facial recognition technology services to law enforcement and some private organizations, both in Canada and elsewhere. It's a US-based company, and the product itself is basically access to a massive database of more than 3 billion odd images that they've scraped from the internet without the consent of the individuals in those photos, obviously, but also, peripherally without the consent of the copyright holders of those images either. Those photos also include links to the location on the internet where the image was found and sometimes other information. So essentially what the service is, you can upload a picture of an individual's face and see where else on the internet that person's face appears. So that has, extraordinary investigative potential for law enforcement and extraordinary potential for abuse. So really, it's a service that allows law enforcement and Clearview's other customers to match photos of individuals against that database. And in the report, the Privacy Commissioner basically referred to it as a 24/7 lineup of billions of people. Fair enough, right? There's an important bit of context here, which is that the OPC actually had a separate investigation into Clearview already when this question about the RCMP was raised. And in that investigation, the OPC found that the company was in a really clear violation of Canadian privacy law, even though Clearview for its part essentially denies, at least in part, that Canadian law applies to it or that it breached Canadian law at all through its activities. And so, Clearview's take in that context was essentially that the information that was available, it was available on the public web, and it was therefore fair game for all those scraping activities that it engaged in, and the eventual use in its product. I think we just need to confront that at the outset. There's an extraordinarily strong privacy interest in faces, in the data associated with our faces. It's intimate, it's highly sensitive, biometric information. It's an important part of our identities, our bodies, and most people's faces don't change over time, right? In fact, faces are both hard and expensive to change, and our ability to conceal them from the state is obviously practically and culturally and legally limited, pandemic masks notwithstanding. So this idea that an image of a face, just because it's on the public web, is fair game to be exploited for algorithmic analysis and to facilitate mass surveillance, I think that's just impossible to square with Canadian law, with the Constitution, with common sense. Okay, so that's the ultra background. And so regarding the RCMP specifically, the investigation of the RCMP sort of flows from this earlier investigation, or this preliminary investigation into Clearview. And what the OPC report discovered or confirmed was that as of October 2019, the RCMP had secretly purchased 2 licenses to use Clearview, and it had also had a bunch of free trial accounts since that time. And I think we're talking about 19 accounts in total. And that these records, Clearview's records, eventually revealed that RCMP accounts conducted at least over 500 searches, the vast majority of which were essentially unexplained or unexplainable. It's really critical to note here, as you mentioned at the top, right, that when the RCMP was first approached by the the OPC regarding its use of this technology, it denied using Clearview's technology altogether, and that's in January 2020. But like about a month later, Clearview's client list was stolen. So of course, the RCMP was on that list, and there was in parallel a significant journalistic investigation taking place, at which point the RCMP admits to the OPC that it had in fact been using Clearview technology, and in fact that it would continue to do so even though there was an ongoing OPC investigation. So at that moment in time, around that moment in time, the RCMP's position was, okay, well, actually we are using it, but we're only using it for really limited purposes, and basically just for identifying and rescuing children who are victims of online sexual exploitation and violence. And then a few months later, the RCMP says it's only used Clearview technology 78 times, or it's conducted 78 uses, whatever that word means. And that the majority of those were either for testing or to identify victims. So at that point, then the OPC is under the impression that this is still a relatively limited set of use cases and contexts. And it's only once the OPC actually analyzes Clearview's own records that we get this number of 521 searches. So the ultimate conclusion of OPC's findings here is that based on the information available to them, only about 6% of the searches that were conducted had any relationship to identifying victims. And then a full 85% of those searches were totally unaccounted for. There is still no explanation of what the RCMP was doing with that technology. So where does that leave us? Well, in part in response, well, probably a number of factors, but our Clearview stopped offering services in Canada in, I believe, July of last year, so around this time last year, which means that the RCMP is no longer using it, that other law enforcement agencies in Canada are theoretically no longer using the technology. But the report is still important for a number of reasons, in part because of the nature of the OPC's findings, the kinds of legal arguments that the RCMP seem to be raising in response, and the fact that the RCMP ultimately disagrees with the OPC's conclusion that it was violating the law, which suggests that it's going to continue to rely on these sorts of specious legal theories to justify future surveillance and use of third-party surveillance technology. To be fair to them, the OPC did make a series of recommendations which the RCMP does say that it's going to follow. Whether or not that actually materializes, remains to be seen.
When you provide all the facts, it's hard to know which is more shocking, whether it's the inaccuracies from the RCMP side, the way the data was used and how much of it remains unaccounted, how they now are still disputing some of the RCMP's findings, but it would be useful to delve into that just a bit more as well.
Yeah, for sure. I mean, I think the dishonesty and whether there's an intentional misrepresentation that took place or whether the RCMP is just not in control of what its employees, its officers are doing, such that it didn't realize that the technology was being used. In either case, I think we should be profoundly concerned about that fact alone. I think that we should also be really worried about the way some of the conclusions that the OPC comes to on a legal basis. So the OPC basically says Clearview violated Canadian privacy law. There's just no question about it. And it says that in these kinds of contexts, the RCMP can't use a tool that is itself illegal to conduct its investigations. There's a quote from the report. It says, and this is a good summary here, in essence, a government institution cannot collect personal information from a third-party agent if that third-party agent collected the information unlawfully. Now, I think that that's actually there's kind of some legal nuance there that's not maybe being captured, but in general, I really agree with this. And I think that the thinking behind this is critical, which is that if we accepted that the RCMP could just contract with private entities to do things that it otherwise would not be lawfully allowed to do itself, what we're doing is we're essentially outsourcing the violation of the fundamental human rights, charter rights of Canadians and people in Canada to the private sector, right? So we're basically saying, go ahead and get away with all the rights violations you want, as long as you get that information indirectly from a third party who is doing something you couldn't do directly. Now that can't be how the Constitution works. So I think that's fundamental. Now, there might be certain kinds of exceptions for certain kinds of investigative techniques, but I think that the overarching principle here is fundamental. And I think it's really troubling that in response to these concerns, the RCMP basically took the position that they have no obligation whatsoever to investigate whether or not the third parties they contract with are actually in compliance with Canadian law. All they did was rely on Clearview's own assertions that all the images in its database were quote unquote publicly available information, which is an incredibly loaded term that we can unpack for hours. And so basically it took for granted that Clearview was following Canadian law because Clearview kind of said it was, and that's not good enough. The OPC, and I think many scholars and advocates and lawyers are concerned, that the RCMP essentially seems willing to abrogate or deny its responsibility to respect Canadians and people in Canada, their charter rights, basically on the basis of bald assertions from private companies. So that's profound. It's serious. Another piece is that the RCMP itself had no mechanisms in place to keep track of what it was doing with this technology. And there the OPC said that there were serious and systemic gaps. And again, we're talking about, it's scandalous, it's a huge problem, but here we're really talking about one specific service, one specific use case, one specific kind of technology. And if this infrastructure isn't in place for use of facial recognition tech like Clearview, we can be sure that it's not in place for other kinds of privacy invasive technologies as well. So I think that there's a systemic problem there where not only does the RCMP have a use first, apologize later kind of approach to novel surveillance technologies, but they're also not keeping good track of what they're doing with them live. And that creates incredible problems for review, for oversight, for recourse in the event that people do try and seek remedies from the courts. And so I think that there's just a fundamental problem of accountability at the heart of all of this.
Yeah, no, that's really helpful. And I think it highlights the systemic issues are really where I think a lot of the concern does indeed lie. But I have to say that, when you talked about sort of how this is, in a sense, nothing new, that we've seen this story before, it's always the same. You made the argument that there's really a straight line between this kind of case and surveillance, even of social movements decades ago. Can you explain a little bit some of that history, the broader context upon which we're seeing these issues emerge now on facial recognition technology, but in some ways, the issues have been recurring literally for decades?
This piece is really important. It's actually at the heart of the complaint that was originally filed about the RCMP use of Clearview technology by Member of Parliament Charlie Angus. And his complaint that he filed raises this issue directly. He talks about the importance of Indigenous-led protests against mega resource projects, against the government. He identifies that there's been a history of distrust between those participating in political protests and the RCMP. And he asks in his complaint, could technology such as Clearview AI be used to identify protesters and create profiles of civic dissent? And so his question, this overarching question, to me is really underneath all of this. So when we talk just about facial recognition technology, I think it's obvious from the OPC's report, from our own constitutional jurisprudence, from basic common sense, that these technologies represent a privacy risk. And I think that while that individual intrusion is important constitutionally and practically, it's not the whole story. And you know, to be honest, and while there's, I think, really important and meaningful scholarship on this point, I'm not personally that interested in privacy for privacy's sake. I'm interested in privacy because I'm interested in freedom, you know, with all of the complexity and historical contradiction that word entails. And so I think when we think about the threats raised by facial recognition technology, other forms of algorithmic technology in the hands of law enforcement, we need to sort of move beyond this idea that it's a purely individual rights issue and look at the ways that technologies of censorship, of surveillance, of control have been used historically in this country and in others. And there we see, you know, like a history that goes all the way back to the founding of the RCMP, you know, to police. I mean, the RCMP was literally created to surveil Indigenous people, right? The idea, you know, Sir John A. Macdonald gets this idea from the Royal Irish Constabulary, which is like a paramilitary force that the British used to keep Irish people under control. You know, so the history of surveillance as a means of political control, not of crime fighting, but of political control, is at the moment of conception in our history for these forces. And I mean, we see this thread throughout history. We see it very recently. We can look at the SPVM surveillance of journalists just a few years ago in Montreal. We can look at the surveillance of women's rights organizations going back to, you know, the fight for the vote, to the fight for reproductive justice. Steve Hewitt has written quite a bit, among others, on surveillance of women's movements and the abortion caravan by the RCMP. Surveillance of campus movements, you know, has been an issue in Canada, a documented issue in Canada for decades. You know, anti-racist groups, the surveillance of Black Lives Matter activists, I Don't Know More activists, environmental activists, Indigenous groups, on reserve, off reserve, all kinds of different human rights movements. We can look at the, you know, the surveillance of prominent individuals like Cindy Blackstock. We can look at the surveillance of veterans activists. Like this is you know, central, and you know, in the cross-border context, I'm sorry, Muslim and Arab individuals in particular. Just I think that it is essential to understand that the surveillance of social movements, of political opponents, this is part of law enforcement and intelligence in Canada. It is, these kinds of abuses can be pointed to throughout our history. We need to understand them in a historical context, and we need to understand that the role that these emerging technologies play. So when we talk, you know, kind of more recently about social media surveillance of Indigenous or Black Lives Matter activists, this is par for the course, right? And so I think it's ahistorical. I think we're missing an important point here to look at this one issue, you know, with Clearview, where the RCMP first denied that it was using the technology and then eventually kind of gets caught using the technology as an isolated incident. This is really part of a pattern.
Lex, that's a historical tour de force on the origins of the RCMP and how these concerns are truly longstanding. Now, before Clearview AI and facial recognition technology concerns, there were IMSI catchers. Can you tell me a little bit about what those are and how that issue played out?
IMSI catchers are devices that internally the RCMP and other law enforcement agencies in Canada called cell site simulators. Sometimes they're known as Stingrays, which is like a brand name. But essentially, these are little boxes. They mimic a cell tower, and they collect mobile identifiers associated with individual cell phones. And because basically everyone has a cell phone, what these devices give law enforcement the power to do is to track, among other things, the movement of a particular device over time. So while there's this idea, or there was an argument, that individual mobile identifiers, it's not like your name, we don't know exactly who you are, why is this so privacy invasive? The reality was that once you had this data in aggregate over time, you could track an individual's movement in really complex ways. And location data is some of the most intimate personal information we have, in the sense that, if you know that somebody goes to this mosque, or attended this protest, or visited this brothel, or appears to be spending a lot of time around a specific group of other devices, other people, you can learn really intimate information about a person. Sometimes we learn things that people don't quite even know about themselves yet, from location data. So I think it's, when I first started doing research in this area many years ago now, MC catchers were this really kind of emerging question, because the RCMP and other law enforcement bodies in Canada had denied that they were using them. And we saw the same things there: access to information requests denied, neither confirmed nor denied, no information. And then gradually it became, oh, well, they're only being used for serious crimes. It ultimately becomes revealed that they were being used for a period in time without any prior judicial authorization or any supervision at all. Later, there were kind of inadequate forms of supervision taking place. I mean, it's the exact same pattern where these private sector companies sell fun new toys to law enforcement. They use them without the public's knowledge, consent, permission, awareness. They deny it to the press. They deny it to researchers and journalists. And then once these technologies are sort of entrenched in the way that law enforcement does their work, then we start having a conversation about how to kind of retroactively find ways to make them legally permissible. And we're seeing the same thing now for the use of sort of risk scoring technology, algorithmic technology. I would point your listeners to an incredible, just a phenomenal report from Kate Robertson and Cynthia Koo and Yolanda Song to this effect, produced by Citizen Lab and the IHRP, which is now under censure. U of T is under censure. That report is phenomenal, because it gives us such a current and in-depth view of the different kinds of emerging technologies that are being used by law enforcement in this country. And I mean, we're going to see the same thing, not just with that technology, but we're going to see it with drones, for example, at protests. We're going to see it in other kinds of applications. And we're really talking about a systemic issue here, right? Where, maybe there's a meaningful public conversation to be had about the extent to which the public believes that the use of these tools is democratically, politically, constitutionally justifiable. But we're not having those conversations. Instead, what's happening is we're getting a sort of trickle truth approach, and we're getting a sort of post hoc rationalization, that I think really sells the public short in terms of their right to know, and in terms of our right to decide collectively as a society how much of this technology we really want in our lives. So I think when we circle back to this history of surveillance of social movements, the relationship between surveillance and freedom of expression, I think it's critical. We're not just talking here about we're not just talking about individual privacy rights. We're talking about the ability of people to express themselves, to assemble, to participate in democratic life. The sort of term of art here is chilling effects. We know that people change their behavior when they're watched. That's fundamental. And so there's a really profound relationship between surveillance, or the perception that we're being surveyed, and the ability to fully participate in public life and to express ourselves. And of course, and I feel totally remiss that, I haven't brought this up at first, but of course, like, there's a vast amount of literature around the fact that these technologies often reproduce and exacerbate systemic racism. That they contribute, for example, the use of pre-existing mugshot databases, right, include massive overrepresentation of Black and Indigenous individuals. So when you start using facial recognition technology with these kinds of databases and source data, what we have is a system that reproduces inequality, in the sense that white people who are engaged in criminal activities are going to show up less in these databases because white people are less likely to be targeted, investigated, caught, or prosecuted to begin with, because of the reality of racial profiling. And so I think that we have to kind of understand all of this as part of a coherent whole. And I guess my last thought on this, and I think it's tightly connected to the freedom of expression and the public participation issue, but where do we see these new technologies rolled out first? Well, it's on vulnerable populations of people who don't always have the capacity or the ability to prioritize resistance to these highly technical kinds of development. So take, for example, surveillance of migrants. We saw, in Petra Molnar and I have written about this idea that in the context of AI, that a lot of these algorithmic technologies are being first rolled out on populations with less access to recourse through the courts, and high risk, high stakes, kind of low oversight context first, like in the context of immigration and refugee law. Tamir Israel has written an incredible and extraordinarily detailed and up-to-date report about the use of this technology by the CBSA in cross-border context. And I know you had him on your show already to talk about this. So, I don't want to go into too much detail, but it's, the use of borders as a kind of civil liberties choke point is really, really critical to understand. And of course, whenever we're talking about technology like facial recognition, we have to think about, well, who's stuck in public space more often? So people who are living in poverty, people who have less access to privacy, people experiencing homelessness who have no choice but to live their lives in public are always going to be disproportionately affected by these kinds of technologies. So we have to have, I think, a real historical approach, understanding the relationship between, law enforcement and the surveillance and the policing and the repression of social movements, but also understand the sort of day-to-day equality rights risks that these kinds of technologies can pose.
Why don't we close with this? You mentioned that I had Tamir Israel on the podcast. I've had Nasma Ahmed as well. So there's been some focus on facial recognition technologies in the past and on this program. And there's been discussion, of course, about a need for a ban, at least in certain contexts, until we set or establish some of the legal rules that provide some amount of safeguards. But when I hear you sort of walk through the history and the impact that these kinds of technologies have, that even that feels inadequate. I mean, this feels like a bit of a whack-a-mole type of game when each technology comes along, and so that the problems are so deeply systemic and historical. I guess I'm wondering, do you have thoughts about how we go about addressing some of these issues? Is it just to continue to play this sort of whack-a-mole game, rely on MPs to raise concerns and privacy commissioners to put out reports? Or is there something more that can be done that sort of addresses more directly some of these truly pervasive and long-standing concerns that you've identified?
There's a lot of layers to that. I think that the thing I want to foreground in answering this question is that if we want to stop playing this game of whack-a-mole, if we want to stop playing a purely defensive game, then I think that what we need to start thinking about really critically is how to connect this conversation around abuses of technology in the service of surveillance and censorship and other kinds of human rights abuses with conversations that are happening in community around what exactly we want the role of law enforcement to be in our society. And there are really powerful and important movements calling for defunding and abolition. And I think technologists need to think very seriously and carefully about how their work intersects with those demands from people who have been working on criminal justice issues for a long time. So I think that, so when we talk about a moratorium, yeah, I think that's a critical first step. I think that it's fundamentally irresponsible for a government to be deploying these kinds of technologies on a public without their knowledge, without their consent, without a meaningful democratic process legitimizing, that choice. But I think also, we need a fundamental reorientation to how we think about the legitimacy of states using these technologies. And so you can look to, like, for example, in the environmental movement or in philosophy, there's this idea of a precautionary principle, and I think that that's part of what's missing in how we think about the use of of this technology, in the sense that it's always, could we plausibly use this technology to catch somebody potentially committing a crime? And the answer to that is always going to be yes, but it's not the right question to be answering, right? We need to think about the values of not just reliability, but also about necessity and proportionality of these technologies, the trade-offs they come with in terms of our democratic rights. And I don't want to at all glorify past approaches, because historically these issues have always been problematic, but I would say that there's a marked difference between how legislators are approaching these issues today and how they historically did. If you look, for example, to the criminal code, we do have prescribed legal frameworks for the taking of fingerprints, for the taking of DNA samples, which are both, extraordinary privacy invasions, and that are part of the criminal law. So those kinds of specific legal frameworks written into statute that are democratically approved are totally absent in the context of a lot of emerging technologies that don't fit neatly into the regimes we might have for, wiretapping, for example. And so I think, the legislature has a serious role to play in forcing these conversations to be happening publicly, openly, democratically. I think that the rule ought to be that technologies are not adopted at all until we know that they're safe, until we have had a public conversation about them. And here's another thing, and it goes back to this conversation about MC catchers, but so many of these things are kept from the public on the basis of this idea that if the public knew that certain investigative techniques were being used, it would interfere with those investigative techniques, their ability to be effective. And so that's the legal pretext that's used to keep the public from knowing that these technologies are being adopted in the first place. And in the vast majority of cases, that justification just doesn't hold water at all, right? For example, with facial recognition, what are you going to do? Stop having a face? The fear that these technologies could be meaningfully circumvented by, to me, it's specious. It's a totally disproportionate argument. Same thing with MC catchers. To get around an MC catcher, you basically have to turn your phone off, right? And so for these systems to work, I think that we really need to examine this idea of secrecy by default. I think it's impossible to square with the democratic values that underlie, our charter, underlie our constitution more generally. So that's a big piece of structural change. There's, I think that, and then here's this other thing, and the OPC is limited because of its jurisdiction, so I don't want to be too harsh on them for this, but to me, the fact that these technologies are being used, sometimes there is this idea that because we exist in a legislative vacuum where there are very clear written rules, for example, in federal privacy law, there's this idea that, well, anything goes, or that things are legal until the legislator makes them illegal. And that is not true. That's not true because we have a Charter of Rights and Freedoms that protects the right to privacy. It protects the right to freedom of expression. It protects our Section 7 rights to life, liberty, and security of the person. And so the reality is that a lot of these activities are in fact unconstitutional, but there are huge access to justice barriers and evidentiary barriers to litigating them. And I don't think it's ideal for anyone to exist in a society where the police kind of systematically adopt new technologies that adopt that violate people's rights, and we have to rely on criminal defense lawyers and class action lawyers and constitutional litigators to bring cases of their own initiatives to put an end to these practices. So there's got to be a certain amount of proactivity on the part of the government and on the part of lawmakers to say, well, you know what, let's first make a public decision about what we're going to do here. We'll test that constitutionally. We'll develop a theory of how to minimize harm, how to ensure appropriate safeguards and guardrails, and then we'll move forward. And so I think, we need a complete reimagination of all of this. But the starting point has to be a kind of precautionary principle. It has to be a moratorium on these kinds of technologies as a sort of baseline to have further conversations.
Lex, so much to think about, and obviously so much work to be done. Thank you so much for joining me on the podcast.
Thank you so much for having me.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.